right. So, welcome everyone. I'm glad that you can join us on this Friday, either afternoon or evening, depending where you are, or even morning. My name is Ihl Inaction. I'm the International Humanitarian Law Regional Coordinator for Eastern Canada at the Canadian Red Cross. So welcome to the 2020 Dalhousie International Humanitarian Law Conference, this year on the topic of armed conflict and the environment. So with me today, I have Karen Stone, my colleague that covers Western Canada for Icho programming with the Canadian Red Cross. She will be here if technical issues arise to answer some of your questions as well during the conference. With me as well are my co-hosts, the wonderful members of the John E. Reid International Law Society, JERILS at Dalhousie Schulich School of Law. And you will hear from some of them today as they will provide some opening and final remarks for the conference. And on behalf of the Canadian Red Cross as well, I would like to also welcome and thank Dean Richard Devlin of the Schulich School of Law at Dalhousie for joining us today to provide opening remarks. We've been partnering with Dalhousie and JERILS for 16 years now for our annual conference. And this year, of course, in light of COVID, we decided to maintain these many years of collaboration and momentum with a conference online. So a big thank you as well to our esteemed panelists who are joining us from the United Kingdom, Geneva, the United States, and Halifax as well, here in Nova Scotia, Canada. So a few technical points before I hand the floor over to Evan Hall from JERILS. So you will see that as an attendee, you are muted. We are accepting and encourage questions, of course, via the question and answer button you see at the bottom of your screen. So you will hear us convey your questions to the panelists during the Q&A periods. So one after the keynote remarks and then one after the panel. We won't be able to address all the questions, unfortunately, but we'll try to answer as many as possible. You'll also see that the webinar has a chat function. If you have any technical issues, we'll try to address them as possible, but we would ask you to only use the chat function for some technical problems and really use the Q&A functions for the questions that you might have. And please also note that today's conference is recorded and the recording will be available online on the Canadian Red Cross website, hopefully next week. So if you're not able to attend the whole conference or have friends, family who would like to listen to the recording, it will be available online. So I will now pass the floor to Evan Hall, the JERILS co-president, for his remarks.
Thank you so much for that introduction, Marie-Laure. Hello, everyone, and welcome to the 2020 International Humanitarian Law Conference, hosted by the John E. Reid International Law Society, or JERILS, and the Canadian Red Cross. Myself, along with Claire Lingley, are the co-presidents of JERILS, and we are thrilled to once again bring this conference, and we'd like to thank the Red Cross for their partnership in this endeavor, as well as the Schulich School of Law for helping coordinate it. Now, things are obviously very different this year than they have been in the past. Usually this conference would be held at Weldon, which is the school, the building that we're usually in for law school. But it's provided us with a unique opportunity to open this conference to members all over the world and individuals who are interested. And so we've been able to get some exceptional panelists from, as Marie-Laure mentioned, from the United Kingdom, from the United States, as well as Geneva, and then right here in Halifax. So we are thrilled to open this conference, and as well, it is my great pleasure to introduce Mr. Dean Richard Devlin of the Schulich School of Law to provide some opening remarks for the conference. Everyone else here has far more interesting things to say than I do, so without further ado, I'll pass the floor off to the Dean. Mr. Devlin.
Thanks, Evan. Is everyone hearing me okay? We're good? Okay, great. So my name is Richard Devlin. I'm actually the acting dean of the law school while Neil Cameron's on medical leave. Thanks, Evan, for the introduction, Marie-Laure, for organizing this. Although this is a virtual workshop, I think it's important to acknowledge that the Schulich School of Law and Dalhousie are situated on the ancestral and unceded Mi'kmaq territory. that we fulfill our university mandate and responsibilities at the hospitality of the Mi'kmaq peoples, that we are all treaty people in Canada, both Indigenous and those of us who are settlers, that the moment of reconciliation is now, and that reconciliation is both an institutional and personal responsibility for all of us, and that we at the Schulich School of Law see reconciliation as a top priority. I have to confess that I actually know very little about international humanitarian law, but actually I know quite a lot about this conference because for several years my niece was very much involved in the organization of this conference. And over the years, given that I'm her uncle, she hasn't actually thought very much about lawyers or thought very highly of lawyers. But through her collaboration in this conference, she's come to recognize that lawyers actually do care about humanity, they care about human rights, and they care about the environment. So I actually do have a bit of a track record, even if vicariously, with this conference. As my lord said, this is the 16th International Humanitarian Law Conference hosted with the Red Cross and Dalhousie. This is a significant achievement. In particular, the description for this year highlights three things: the protection of the environment before and during armed conflict, impacts of damages to the environment on civilian populations, and thirdly, environmental post-conflict recovery. Now, these are obviously enormous challenges facing our society on a global scale. They require big thinking, they require imagination, they require collaboration, and most importantly, they require political will. They also require short-term engagements, medium-term planning, and long-term aspirations. The impact of the COVID pandemic has obviously multiplied these challenges significantly, especially on the most vulnerable and marginalized communities locally, nationally, and internationally. The scale of these challenges could be paralyzing, but through organizations such as the Red Cross and the Red Crescent, the progress can be made. You are a beacon in what seems to be a very long night. Similarly, Dal Law School might be a small law school stuck out somewhere in the middle of the North Atlantic, but our faculty, our students, and our alumni have significant humanitarian influence globally, disproportionate to the size of our and location. And it's often because of initiatives and conferences just like this. So on behalf of the law school, I want to thank the organizers, the panelists, the attendees at this conference for everything that you're working on. I have every confidence that despite being online, this will be another outstanding conference. So good luck and thank you for inviting me. Take care.
Thank you very much, Dean Devlin, for joining us this morning. You're of course welcome to stay as long as you can, but we also understand obviously that you must be very busy, especially in these very trying, difficult times. So of course you're free to go whenever you need to. Before I start with my introduction to international humanitarian law, I would have a question for you all, just so we know what your background is, where you are from. So I'm just launching a poll right now. I'll give you maybe 15, 20 seconds to tell us about your field, your occupation, generally speaking. And you can also type in the Q&A box which region, which country you are from, so we can know a little bit more about you, our attendees today. So yeah, I'll leave you maybe another 10, 15 seconds. So, perfect. So we've got, yeah, people from all over the world, from apparently many different fields. So that's great. That's great to know. So I'll just, perfect. So here we are. Yeah, so people from all around the world, a lot from Canada, of course, but we have New Zealand, Turkey. I think I've seen Pakistan as well. So yeah, many people. So Colombia also, great. So I will, without further ado, because time is limited, I will go ahead with a presentation that we wanted to, it's our traditional presentation on international humanitarian law, just to give you a background on this very important body of law that you'll hear quite a bit about today. We've talked about protection of civilians, for example, during armed conflict, or effects of the armed conflict on civilians, and that's where Icho comes into play quite a bit. So we'll briefly speak about what Icho is and what it's not. We'll talk about also briefly the history of IHL, the rules on, the rules on the conduct of hostilities as well. And we'll explain also what is the conduct of hostilities. So what IHL is and what IHL is not. So it's really important to distinguish IHL from another body of law, what we call jus ad bellum, so the law on the resort to war. So we all know generally that war is prohibited. It's in the UN Charter. That's what's set out in the UN Charter, except in cases of self-defense. That's also a big academic debate, but we won't get into that. Or in cases of authorization by the UN Security Council. However, sometimes there will be war, there will be conflict, and at that moment, when we cross into that time of armed conflict, IHL will start applying. So IHL will specifically govern situations of armed conflict. So these rules will seek to protect persons who are no longer participating in the hostilities, and to restrict the means and method of warfare. So basically to establish rules to tell peoples that are fighting, to tell the belligerent, this is what you can and cannot do and how you can do it. So whether the conflict is legal or not, based on what you see on the left of your screen, regardless if it's a legal or illegal conflict as per the UN Charter, as per international law, IHL will always apply. It's a body of law that's quite pragmatic and quite realistic, in the sense that it will just see, based on the facts, that there is an armed conflict, and it will seek to protect people that are affected by this conflict. It will seek to limit, for that reason, how people can fight. IHL will also interact sometimes with other bodies of law that you might have heard of, for example, international human rights law, or some domestic laws as well, but it's also its own body of law. And again, completely different from the law on the resort to war, jus ad bellum, that you see on the left of your screen. So basically, IHL will be saying, well, there is a conflict now, we need to protect certain categories of people, and that's why it's applying now. So you can see certain examples of protective treatment, protective rules that IHL includes. So as I mentioned, people that are no longer or not taking part in the hostilities, for example, civilians, they cannot be targeted, as many of you know, and they must be treated humanly. For example, if they come if they end up in the hands of the enemies, they must be treated humanly. And that's why, for example, torture or cruel treatments, taking hostages are prohibited. Some other categories of people also will be protected under IHL. So the sick and wounded, for example, humanitarian access for civilians in need must also be ensured and respected. And there's also some special protections for people that might be in other situations of vulnerability. For example, the displaced or the children, people who have some disabilities as well. So IHL is a balance, and we always need to keep that in mind. So we would all like for wars not to exist. We will all like to be out of a job. Us in the IHL, let's say, world, if one day we would be out of a job, it would be good news, because it would mean that wars do not exist anymore. But they do still exist, unfortunately. So IHL is, as I mentioned, quite pragmatic, in the sense that it will recognize that, on the one hand, someone or a party, an armed force, will need to resort to certain actions to try to overcome their adversary. For example, they will need to cause some injuries or destruction in order to overcome the adversary. But on the other hand, Icho also makes very clear that this military necessity, that these military considerations cannot give the belligerents like a carte blanche, and that there are considerations of humanity that will impose these limits on the means and methods of warfare, on what they can and cannot do while they fight. And all the rules that we're going to see in the next few minutes really come from that balance. So a quick history, I'll try not to take too much time. So the man you see there is Henri Dunant. He was a Swiss businessman. So he was one day traveling to Italy. He wanted to meet Napoleon, probably to discuss some business matters. And he saw the Battle of Solferino. He just witnessed that, and he saw with horror that there were hundreds of soldiers that were left on the battleground. They were injured, they were dying, and nobody was attending to them. So he went to the neighboring villages, and he got the citizens there to come and help him to care for these wounded soldiers. And they cared for the soldiers of all the parties. It didn't matter who they were fighting for, they cared for them all. So he returned to Geneva, where he was from. He was still quite shocked, and he wrote a book called A Memory of Solferino. And then he and four other men later, in 1863, they met and they created a committee, what was called back then the International Committee for the Relief of the Military Wounded, which will become the International Committee of the Red Cross. And they then prompted the Swiss government to convene a diplomatic conference. And at that conference, 16 states came and they convened, they adopted the convention for what was called back then the Convention for the Amelioration of the Condition of the Wounded in Armies in the Field. So that was the very first Geneva Convention. So you might have heard in movies or elsewhere about the Geneva Conventions. Well, that was the very first one. And then there were other versions of the conventions adopted over time, and that started to cover other people. So it was not only wounded soldiers anymore, it was also shipwrecked sailors, civilians as well. And now we have 4 Geneva Conventions that were adopted, the final versions in 1949. And also in 1977, there were 2 additional protocols that are also treaties that were adopted to complement these rules that are in the Geneva Conventions. And what is important about the Geneva Conventions as well is that they are universally ratified. All states around the world have ratified the conventions. All states around the world are bound by these conventions. So that's another very important point to stress. So we saw that IHL applies in times of armed conflict. But you might wonder, but what exactly is technically an armed conflict, and when is there an armed conflict? So to know whether there is one, we need to really look at the facts in the situation on the ground, at the actors that are involved in a conflict. The Geneva Conventions and the protocols mention 2 types, so international armed conflict and non-international armed conflicts. So when is there an international armed conflict? Well, when there's a use of armed force between at least 2 states, so it's international. And as soon as there's an act of violence, for example, a missile is launched from a state onto the territory of another state, well, we have an international armed conflict. Second, we have a non-international armed conflict, which is a conflict between a state and a non-state armed group, or between armed groups themselves. Because the Geneva Conventions and the protocols mentioned these 2 conflicts, but they didn't really provide a definition. So that's why we'll be explaining these criteria. So for the existence of a non-international armed conflict, we need to see two cumulative conditions. So first, a threshold of violence. So it's basically trying to evaluate if, unfortunately, the confrontation is violent enough. So we'll be looking at the number, the duration, the intensity of these confrontations. We'll be looking at the number of people taking part in the fighting, or evaluating the number of casualties, the extent of the destruction. We'll also be looking at if the groups that are fighting are organized enough. So a non-state armed group, for example, might have a command structure and some disciplinary rules. They might have an HQ. They should be able to plan and execute military operations. So that demonstrates a sufficient degree of organization. And if these two criteria are met, then we'll be in front of a non-intentional armed conflict, and IHL will start applying. Sometimes we'll see riots, for example, protests, but it's not necessarily violent enough or hasn't lasted long enough, or other criteria, or the groups that are fighting are not organized enough, that then we'll often call them other situations of violence, and that's not, as per IHL, an armed conflict yet. It might evolve into a non-international armed conflict, but it's not yet, and in that case, IHL doesn't apply, but it will instead be, for example, international human rights law. So that brings me to human rights law. So a lot of people have heard about that. So we have, of course, situations of peace, but of course, as I mentioned, situations where there's an armed conflict. Human rights law will apply at all times, whenever there's an armed conflict or not. As we saw, IHL will only apply when there is an armed conflict. Some rules, generally speaking, some prohibitions will exist in both. For example, both IHL and human rights law will prohibit torture. There's also other rules that only exist in human rights law, for example, freedom of expression. There's no mention of freedom of expression in international humanitarian in international humanitarian law, IHL. So that's something we need to keep in mind. Sometimes these rules will overlap, but they both have, let's say, the same aim, which is to protect the safety, the dignity, the health, the life of people in general. So as I mentioned a bit earlier, there's always a balance in IHL, military necessity versus humanity. So conduct of hostilities is really about the rules that are applicable in the actual fighting. And there are three of them: distinction, proportionality, and precaution. And we'll be going through them in the next few minutes. And these three rules need to be respected for an attack to be able to take place lawfully under IHL. So before each attack, it must be determined if these three criteria are respected. And if they are not, then the attack must be canceled or suspended. So the first principle, which you might know as well, is distinction. So the parties that are fighting must distinguish when they attack between combatants or fighters and civilians, and between military objects and civilian objects as well. So when we talk first about combatants and fighters and versus civilians, well, we remember that civilians cannot be targeted. They are not participating in the hostilities unless they temporarily lose that protection. But that's a whole other lecture that we could give. That's too long. But they are protected from any targeting that can be done in attack. They cannot be directly targeted. Second, an object, to be a military objective, has to meet two criteria. So we'll be looking at something and we'll be evaluating if this is a military objective lawfully. So the object, by its nature, its location, its purpose, has to be contributing effectively to the military action of the enemy. So for example, a tank. So a tank by its nature will always be considered, or almost always be considered, a military objective. And also the second criteria is I'll be looking at that object and I'll be wondering if its destruction, its capture, its neutralization will offer me, a party to the conflict, a definite military advantage in the circumstances at the time. If so, if these two criteria are met, then it's a military objective. There's also certain special protections for certain objects, for example, religious buildings, cultural buildings, et cetera, et cetera. And there's also certain categories of people, for example, medical personnel, that are protected as well. So the next important principle is proportionality. So if I'm thinking of the tank, if we go back to the tank, I determine that it's a military objective. I'll get an advantage if I destroy it, for example. But what if that tank is in the middle of a village? So that's when the principle of proportionality comes into play. So the parties to an armed conflict cannot launch an attack against lawful military objectives if the attack may be expected to result in excessive civilian incidental damage. So sometimes you'll hear collateral damage. Well, that's what it is, even if it's not really the language we like to use. But so if they evaluate that damage when compared to the military advantage they are anticipating, then it cannot be excessive. But of course, it's very difficult to evaluate because, for example, what is excessive for me might not be excessive for you. And also that analysis is done before the attack is launched. So it's always hard to evaluate, well, will that damage to the civilian population and objects be excessive for what I'm going to gain? It's definitely very difficult to determine. And that principle also comes into play in terms of choices of means and methods of warfare. For example, by choosing a weapon that can minimize damage to civilians and civilian objects, well, I would be applying the principle of proportionality. So for example, I will not be using, as a party to the conflict, a bomb, when instead I could just be using a smaller kind of arm to achieve that objective that I have. It could also be about launching an attack at a certain time of day, because I know that most civilians in that, like at that time, are elsewhere, far away in the fields or something, and that when my attack takes place, my damage to the civilian objects and injury to the civilian population will be much lower. So that's just an image that we use. Of course, it's an exaggeration, but it's just to show you, for example, these two men at the middle of your screen that are in the little trench there are an enemy of these people in the tanks. Of course, do I need 4 tanks and like 5 cannons to injure or eliminate these 2 soldiers of my enemy? Probably not. Especially, or even most definitely not in that case, especially since we see at the bottom of the screen that there's a village around, right behind. Sometimes it can be really tricky because my military objectives will be, let's say, the head, the big boss of the group I'm fighting against. So that for me is a very big, important military objective and gain that I would get. So that's also going to come into the balance when I am evaluating how I'm going to attack that person, for example. Precaution is basically, as it's a third principle, and it's really, it's a culmination in a way of distinction and proportionality. It must be, again, applied during all phases of the attack. So when I'm planning the attack, but also when the attack is taking place. So it holds basically that the parties to the conflict must seek to avoid, or at the very least minimize, the harm made to civilians. Because we'll remember, of course, that civilians and civilian objects are protected. And you avoid that by taking all feasible precautions. So what are feasible precautions, you might wonder? Well, it's precautions that are for you as a party practically possible, of course, taking into account all their circumstances, of course, taking into account humanitarian considerations and military considerations as well. So that means that you need to verify, you do everything feasible to verify that what you're targeting is indeed a military object. You need to choose means and methods that will minimize the incidental harm to civilians and objects. You need to refrain from launching an attack if it's clear that the loss or the damage caused would be excessive in relation to the military advantage that you're anticipating. You need to give warnings, again, if attacks may affect the civilian population. And you need, as a party to the conflict, to cancel or halt attacks if it's determined that these rules cannot be complied with. So that's, yeah, the third principle at the core of the conduct of hostilities, at the core of what the parties can and cannot do and how they must conduct the fighting. So how to ensure compliance with Icho? So that's always a very big question that we're being asked and that people might wonder about. So there's many ways to ensure that compliance. There's, for example, Common Article 1 of the Geneva Conventions. So in all 4 conventions, there's this one article that says that the states have an obligation to respect and ensure respect for Icho in all circumstances, and that can be done in many different ways. There's also very like a big variety of initiatives that are taken by NGOs, by other organizations as well. For example, the ICRC in educating and training parties to the conflict, or as well the general public. The military does a lot of work that we don't always see to train all their soldiers and their officers on these rules. Some NGOs have directly negotiated with non-state armed groups to get them to commit to respect certain rules of IHLs that would be included in a specific agreement, even if these groups are bound by all the rules of IHL as well. There's also, of course, justice, criminal justice. So, of course, there's the International Criminal Court, the ICC, but there's also domestic courts. There's also, for example, in Canada, the Crimes Against Humanity and War Crimes Act, and many other countries around the world as well have adopted laws that will enable them to prosecute individuals before their domestic courts if they committed war crimes. So, of course, we've all seen horrible images and heard terrible accounts from various conflicts around the world. So it's pushed a lot of people to question the relevance of IHL because they're just like saying, well, you know, what's the point? Because it's not respected. So first of all, it's not true. It's more respected than it's not. We just don't really see it. We see a lot of things in the media, so it creates some sort of bias, but there's also a lot of moments of examples, instances of IHL being respected. There's 2 great databases that were created by the ICRC, the International Committee of the Red Cross. For example, the Ihl Inaction Database, that is basically, literally a database based on facts on the ground that show examples from all over the world, from state armed forces, from non-state armed groups that have respected IHL. And sometimes we'll see, for example, well, okay, there's been a ceasefire, they've been allowing humanitarian aid to come in that specific context. Well, that's an example of IHL being respected. But you'll see that in a newspaper, you won't necessarily realize it, but it is an example. Because when people say, well, IHL is not respected, what's the point? Or sometimes the rules are violated, what's the point? Well, rules will unfortunately almost always be violated. So my favorite answer is to say to people, well, you know, some people won't respect the Highway Traffic Act, or they'll commit acts that are prohibited in the criminal court, for example. But does that mean that they're irrelevant, and that one day, well, okay, well, someone stole a car, so what's the point of the criminal code? We'll just scrap it? Of course not. It's just we need to work harder with all the parties involved to make sure that they know the rules, that they understand them, and then it's practical and realistic for them to apply them. And that's a lot of work that's being done. So it's really important to remember that this perception that IHL is not respected is not only wrong, but it's also dangerous, because it might push people to disrespect the rules and harm the people that are protected by these rules. So the civilians, the wounded, the sick, the people that are not participating in the hostilities. So that's the point I really want everyone to remember. So before we move on to our keynote, I have a few minutes to answer questions that you can pause in the Q&A button, and I'll try to answer them as best as I can. And if, just a reminder to put them in the Q&A function, the Q&A box, and not in the chat, so we can manage them better. And if not, I can also answer some of them at the end, or by email afterwards. I'll be happy as well to answer some questions. So so far there's no. I'm trying to see a question. Yeah. So I will not. I cannot, unfortunately, go into defining very specific situations. I'll, for example, mention in that context or in other contexts that you sometimes also have two different types of conflicts that will that can overlap on the same territory. So, for example, you can have an international armed conflict, and then also on the same territory, on part of that territory, a non-international armed conflict. What's important to remember, however, is that the same rules, generally speaking, or with slight variations, will bind everybody. They will bind the states, they will bind non-state armed groups as well, and they will, again, generally protect the people that don't participate in the hostilities, in the fighting, that can not longer participate. So the wounded, the sick, for example, the prisoners of war, so they've been taken, they can't fight anymore, so there are rules that are protecting them as well, and like just a framework for their detention. And that will regulate means and methods of warfare. So the conduct of hostilities, how people are fighting. So again, that's a big point that that is to be remembered. So for now, I have one. So how can IHL? I have one. How can IHL evolve to cover the new forms of war making? It is evolving. It evolves. It evolves very, very quickly. And if you go, for example, on the website for the International Committee of the Red Cross website, ICRC, you will see they're already doing a lot of work and have reports and organize expert meetings and all that on, for example, cyber warfare or artificial intelligence. There's a lot of course, as well being said about drones and all sorts of vehicles and machines that are controlled by humans elsewhere that are not controlled by humans as well. So it has already evolved. Generally speaking, the consensus is that the same rules will apply to these types of conflicts, for example, involving robots, as sometimes we call them, but it might be a bit more just complicated to apply them to these specific types of conflicts or actors, but these same rules still exist and still apply and are still important, of course. So I've answered another question, cyber attacks, and there's as well a big manual too, actually, that I've gone over these rules of IHL and others with regards to cyber attacks and cyber warfare in general. So it's evolving pretty quickly, pretty well. So, and of the Ihl database, Ihl Inaction, maybe just for a last question. So there, it's not a database that will cover every single conflict so far. So it's always being updated. People are constantly working on it to add new cases. But yes, so far the geographical representation is pretty good, but it's not covering every single conflict so far. But maybe if you go and check it out regularly, you'll see examples being added. I see them. I receive newsletters from the ICRC, and I see new cases all the time being added in French, English, other languages as well. So yeah, I think, and I see, yeah, there's another question on compliance when it's not respected. And well, as with other rules, it's just continuing to educate, to discuss, to negotiate with these parties. It's work that is, of course, very hard. It's work that needs to be done in the long term. It's reminders that we need to give to the parties that some people don't have anything to do with the conflict and they need to be protected. For example, it's also finding ways with them to apply these rules in the context in which they are. And the ICRC, for example, does a great job at that. They're always in discussions and negotiations with the parties to remind them and to discuss these rules. And yeah, that's just to answer that question as well. And then I have a question on, does international humanitarian law really apply in all situations? When there is an armed conflict, so for example, I mentioned Syria or others, when there is a conflict as per the rules and the criteria I've explained, yes, IHL will apply just automatically like that as a body of law. It applies. And yes, IHL covers people that are interned, detained by the parties that are fighting, either civilians for certain reasons, or prisoners of war, or people that are part of non-state armed groups as well. And also there's someone mentioning, and that'll be the last question I can answer before we move to our keynote. Something I didn't really have time to address are the emblems. So you've seen on the last slide a red crescent, a red cross, and as well maybe I can show it. Here it is. Yeah, the third emblem there, the red crystal. So these are the three emblems that need to be respected in times of our conflict, because they signal that someone is part of a impartial humanitarian organization, the Red Cross or Crescent Movement, or in sometimes the case of medical officers from armies. They are protected because they are providing help, exclusively providing help to people that are wounded or injured on the battlefield. So you cannot target, for example, vehicles with these signs. If there is a building with one of these signs, for example, the Red Cross, it's a medical building, it cannot be targeted. That is a war crime, for example. So that was a very good question to mention something that I did not include, but that's also a very, very important component of international humanitarian law as well. And there are rules on these emblems, but that could also be the subject of an entire lecture. But that was also a very good question. Without further ado, in a way, I'll be happy to introduce you to our keynote speaker, and I will just pull her bio up. So Elena Obregon-Jessican, qui has served as a legal advisor with the ICRC Legal Division in Geneva since 2014. And she focuses, among other issues, in her work on the protection of the environment in situations of armed conflict. Previously, she's worked for the ICRC and the British Red Cross on a project on customary international humanitarian law, and in the ICRC's Policy and Humanitarian Diplomacy Division. And before joining the ICRC, she worked for Oxfam International, Trial International, another great NGO, and for the International Cooperation Agency of the Colombian government. She holds a Master of Law in International Humanitarian Law and Human Rights from the Geneva Academy of International Humanitarian Law and Human Rights, and a Bachelor of Science in Foreign Service from Georgetown University in the United States. Without further ado, I will welcome Ellen. I will just pull up her presentation, and then I will pass the floor to her. So welcome, Helen.
Thank you very much, Marie-Laure. Can everyone hear me? Can everyone see my presentation? Yes. Okay, so thank you very much to the Canadian Red Cross and Dalhousie University for inviting the International Committee of the Red Cross to join the discussion today. And good morning, good afternoon, good evening to everyone joining us. It's really a pleasure to be here today. So in my remarks today, I would like to address three areas. The first is why we need action to protect the environment in conflict now more than ever. The second is about how international humanitarian law protects the natural environment. And the third part is about what can be done to strengthen protection. So moving to the next slide and to the first part of my remarks. Why is it important to take action to protect the environment now? So as we all know, armed conflicts spanning from Vietnam to Kuwait to Kosovo to the recent burning of oil wells in Iraq remind us time and again that the environment can be lastingly scarred by war. Too often, it is directly attacked or incidentally damaged by the use of certain means or methods of warfare. It is also impacted by damage and destruction caused to the built environment. So for instance, when water, sanitation, and electricity services are disrupted by hostilities. Explosive remnants of war can contaminate soil and water resources, at times for decades, and harm wildlife. And biodiversity can be irreparably degraded as warfare is waged in hotspots. In certain circumstances, the environmental consequences of armed conflict can also contribute to climate change. So for instance, when large areas of forests are destroyed, this can have detrimental climate consequences. Furthermore, damage to infrastructure, such as oil installations and large industrial facilities, can also force large volumes of greenhouse gases and other airborne pollution into the atmosphere. Next slide, please. The consequences of this kind of environmental damage for conflict-affected populations are severe and complex. People depend on the environment for food and for water. Farmers, herders, fishing communities depend on it for livelihoods. When the environment is damaged or destroyed, it threatens the well-being and survival of conflict-affected populations. For example, attacks can lead to water, soil, and land contamination, rendering drinking water and agricultural land scarcer for those already in desperate need. Climate risks, when combined with this environmental degradation caused by armed conflict, makes matters worse for those trying to survive these situations. The ICRC sees daily the dramatic impacts of the climate and environment crisis on populations living in conflict. Of the 20 countries considered the most vulnerable to climate change, 60% are actually enduring armed conflict, which shows us the linkages between these two situations. In places that have already been damaged by decades of war, people's coping mechanisms are radically eroded. With weakened resilience, they're left vulnerable to additional and further shocks, including those coming from climate change. So the ICRC is already conducting a broad range of activities to reinforce people's resilience and their capacity to adapt to these combined consequences. But our efforts need to be strengthened and refined, and we are adapting our humanitarian action to take these combined threats into account. We recently launched a policy report, When Rain Turns to Dust, which explores the humanitarian consequences of these converging risks and essentially calls for scaling up of collective action to strengthen climate action in these situations. And we are also stepping up our efforts to promote the importance of respecting IHL rules, protecting the natural environment during conflict. So before moving on, I would like to do a quick poll to highlight some of the points I have raised, and we will answer that later on. So Marie-Laure, if you could share that.
So we'll leave you, yeah, maybe 30 seconds, and answers are all anonymous. So there's no, it's not a real quiz. It's really just to pique your curiosity, but don't worry about being identified or anything. So maybe another 10 seconds. There's a pretty good trend towards one answer. Awesome. So we'll end the poll now and share the results with everybody.
Great, thank you very much. And as I said, we'll look at the answer to that a bit later. So if we could move to, the next slide, which is the second part of my remarks on what does IHL have to say about the natural environment. So while a certain level of environmental damage is of course inherent to armed conflicts, it cannot be unlimited. And although IHL does not address all environmental consequences of conflict, it does contain rules that provide protection to it and that seek to limit damage caused to it in war. This protection can be divided into two rough categories. The first type of protection consists of those rules that grant specific protection to the natural environment as such. In other words, that is their primary purpose. And these rules include, for instance, the prohibition against using means or methods of warfare that are intended or may be expected to cause long-term, widespread, and severe damage to the natural environment. And IHL also, for instance, explicitly prohibits attacking the natural environment in reprisal. When adopted in 1977, these were among the first rules to explicitly protect the natural environment in times of war. And the recognition among the drafters of Protocol 1 of the need to protect the natural environment, particularly at a time when this was still quite novel, was an important step towards affirming the importance of this protection. So we can move to the next slide and look at the second type of protection that IHL affords, which has to some extent been overlooked and at times underapplied. This crucial protection consists of general IHL rules that protect the natural environment without this being their specific purpose. So importantly, it is generally recognized today that by default, the natural environment is civilian in character. On this basis, all parts of the natural environment are civilian objects, unless parts of it become military objectives, as Marie-Laure explained in her remarks. Its various parts therefore benefit from the protection that civilian objects get under IHL during the conduct of hostilities. So the principles of distinction, proportionality, and precautions that Marie-Laure also covered. So looking at two of these, the principle of distinction requires that an attack that cannot be directed against parts of the natural, requires that an attack cannot be directed against parts of the natural environment unless it is directed against a specific part of it that has become a military objective. And this can happen if, by its nature, location, purpose, or use, a distinct part of the environment makes an effective contribution to military action, and if its destruction, capture, or neutralization offers a definite military advantage. Quickly on the principle of proportionality before moving to the next slide. Based on its civilian character, the natural environment is also protected against incidental damage. So it is prohibited to launch an attack against a military objective, which may be expected to cause damage to the natural environment that would be excessive in relation to the military advantage anticipated. So an example of disproportionate incidental harm would be, for instance, to cause an entire forest to burn when attacking a single small enemy campsite of minor importance. It is the ICRC's position that the foreseeable, indirect, or reverberating incidental effects of an attack must also be considered in this proportionality assessment. And this is particularly important for the protection of the natural environment, which is often affected indirectly rather than directly by hostilities. So whenever an effect is reasonably foreseeable, whether an effect is reasonably foreseeable will depend on the facts of each case, but an assessment should be informed by past practices and empirical data. And I think Doug will speak to the issue of data a bit later. So we can move on to the next slide, which essentially shows a number of other IHL rules that seek to prevent or limit damage to the natural environment. And these include rules on specially protected objects, such as objects indispensable to the survival of the civilian population. They also include rules on enemy property and pillage. And protection is also granted through the rules on the use of certain weapons. So for instance, rules on incendiary weapons, on the prohibition of poison, of biological weapons, of chemical weapons, as well as rules limiting the use of landmines. So before moving to the last part of my remarks, I would like to briefly address the links between IHL and climate risks. By limiting environmental degradation, better respect for IHL can reduce the harm and the risks to which conflict-affected populations are exposed because of climate change. So for instance, climate change can drive water scarcity and reduce the availability of arable land, both of which are critical to civilian survival in conflict. By prohibiting attacks on objects indispensable to the survival of the civilian population, such as agricultural areas and drinking water, IHL protects these resources from additional conflict-related violence. Climate change can also accelerate biodiversity loss, with resulting consequences for the health and economies of local communities. IHL can provide a framework that designates areas of particular biological diversity as demilitarized zones to protect these fragile hotspots from additional degradation. So we can move to the next slide, which is the third and last part of my remarks on what we can do to strengthen this protection. So as Marie-Laure mentioned, it is of course not enough that IHL rules exist on paper. What is critical is that they be better disseminated, implemented, and enforced for their protective effect to actually be seen on the ground. So to step up efforts on this, The ICRC has actually just released a few hours ago, and our president should be speaking about this in a UN General Assembly side event around now. It's updated guidelines on the protection of the natural environment in armed conflict. So to give just some background on those, the ICRC drew up the first guidelines for military manuals on the protection of the environment, following a consultation with international experts. And these were submitted to the United Nations in 1994. And a General Assembly resolution invited all states to give due consideration to the incorporation of these in military manuals. Since these 1994 guidelines were released, the legal framework has continued to develop. We simultaneously continue to see devastating environmental consequences because of war, which highlight the enduring need to do more to reaffirm and promote respect for these rules. And today, finally, there is also renewed momentum and recognition of the urgency to do more to address the environment and climate crisis. So because of this, and in line with the recommendation of a seminar organized by the United Nations Environment Programme and the ICRC in 2009, the ICRC updated these guidelines to reflect developments in treaty and customary law. In parallel, efforts to clarify and strengthen the legal framework continue. Of note, the adoption and first reading of the draft principles on the protection of the environment in relation to armed conflicts, along with their commentaries by the International Law Commission in 2019. And we really see this work as complementary to the guidelines in two important ways. First, the scope of these principles is broader both temporally and in the bodies of law, of public international law that it draws on. And second, the draft principles reflect and reaffirm the application of IHL to the natural environment. So moving to the next slide, where I would like to just give you a very quick overview of the guidelines and their purpose. They focus on how IHL protects the natural environment and are a collection of existing rules as well as recommendations. We have also added a concise commentary to each rule or recommendation to aid understanding and to clarify the source and applicability of those. The 2020 guidelines underwent a process of external peer review by practitioners and academics who contributed in their personal capacity. And I would like to take the opportunity to thank very warmly Carl, who will speak later, for being part of this process. So what is the purpose of these guidelines? They are a reference tool for states, parties to armed conflicts, and other actors who may be called upon to promote, implement, interpret, apply, and enforce IHL. They intend to facilitate the adoption of concrete measures to enhance respect for IHL, including by disseminating these rules and incorporating them into military manuals, national policy, and legal frameworks. And to support this implementation, the 2020 guidelines also propose key recommendations that parties may take to reduce environmental impacts. For instance, to disseminate IHL, some of these recommendations include disseminating IHL rules and integrating them into armed forces doctrine, education, training, and disciplinary systems. Another recommendation, for instance, is adopting and implementing measures to increase understanding of the effects of conflict and to try to minimize these impacts prior to and regularly during military operations. Another recommendation is to identify and designate areas of particular environmental importance or fragility, such as national parks, as demilitarized zones, which would bar all military action and the presence of troops and military from these, material from these. And finally, exchanging good practices on measures to comply with IHL. States could also carry out or share scientific assessments of damage caused to the environment by certain types of weapons. And recently at the International Conference of the Red Cross and Red Crescent in December 2019, states and national societies adopted a number of pledges of this kind to improve the protection of the natural environment. And these efforts must continue if the health and livelihoods of civilians caught in conflict are to be protected. Moving to my last slide, and I'll close here with the release of the guidelines. The ICRC will now step up its efforts to raise awareness and enhance respect for these IHL rules, which provide protection to the natural environment. Ultimately, we believe that better respect for these rules can limit the impact that conflict can have on the natural environment and the deeply interlinked consequences for conflict-affected populations who so depend on it. And going forward, we stand ready to work with states, parties to armed conflict, and other actors in achieving these goals. So thank you very much again for inviting the ICRC to be part of this conference, and I look forward to our discussion. If time allows, before turning to the Q&A, we would like to share a 1-minute video that addresses some of the elements that I have mentioned and that also answers the poll that we did at the beginning. So thank you very much.
Thank you, Ellen. I will now share the video.
Over 80%
Whoops.
of conflicts take place in biodiverse hotspots. While these spots represent less than 2% of the Earth's land, they support around half the world's plants and many rare species. In the Democratic Republic of Congo, the conflict wiped out 95% of the hippos as their habitat was destroyed and the animals could not be protected from poachers. In Mozambique, the 15-year civil war crushed the elephant population from 2,000 to 200, and sometimes nature itself is used as the weapon. In Iraq, heavy crude oil was pumped directly into a river, affecting the drinking water supply. Yet in some cases, the environment benefits in war, as areas abandoned by people are left to grow wild. The laws of war protects the natural environment, not only because of its intrinsic value, but because it sustains human life. Except in rare cases when it has become a military objective, it is against the law to attack the natural environment.
So, and we saw on that screen another great video made by the ICRC, the Rules of War in a Nutshell, that I encourage everybody to check out. It's very short and sums up very nicely visually as well all the rules that we've mentioned earlier today. So I encourage you all to submit some of your questions in the Q&A box. For Helen, we have about 10 minutes to answer them. And after that, we'll go for a short break before we start with our panel. And I think there was a first question that was submitted during the presentation, and maybe Ellen can start answering, because we'll talk about that a bit later as well. Once the warfare has taken place, and I'm reading out the question, is anything done to counteract the devastation and consequences caused? Any sort of cleanup or replanting of vegetation?
Thank you for that question. And I think I see another similar one in the Q&A box. So, I mean, as Marie-Laure mentioned in her presentation, IHL is concerned with the protection during armed conflict. However, that does not mean, and it is applicable only in situations of armed conflict. However, that does not mean that there are no rules that could be relevant the post-conflict and to, if we look in particular at the issue of explosive remnants of war. So there, I mean, I would just like to share an example of one of the rules that is mentioned in, that is contained in the guidelines, and that's Rule 24, which is on landmines. And here, for instance, among the things that this rule mentions are the fact that when a party to the conflict uses landmines, they must record their placement as far as possible, and that at the end of active hostilities, a party to the conflict which has used landmines has to remove or render these harmless to civilians or facilitate their removal. And here there are additional obligations for states parties to the Anti-Personnel Mine Ban Convention that are also of relevance. Each state party must destroy or ensure the destruction of its anti-personnel mine stockpiles and must clear areas under its jurisdiction or control that are contaminated with anti-personnel mines. So these, that is just an example of one of the rules. It is the most important one that I can think of right now that addresses issues that are relevant in terms of cleanup and post-conflict. But it's an example of how IHL can have an effect and can contribute to the post-conflict, even if its rules are applicable only, the majority of its rules are applicable only during a situation of armed conflict.
Thank you very much. Someone asks for if you could maybe provide an example of a situation in which the natural environment has become a military objective.
Yes, sorry, toggling between the mute button and the different things on my screen. So an example of where, depending on the circumstances, and here it's always very difficult because it really depends on what the military objective is, so what the situation is at that given moment and how the assessment is made. But for example, a hill may make an effective contribution to military action by its location. A hill may contribute effectively to the military action of enemy forces if it provides them with a vantage point over their adversary's camp. Another example can be the foliage in a specific forested area, which may also contribute effective to military action by providing cover for a troop maneuver. So the fact that they provide military action, they contribute effectively to military action does not necessarily in itself make it a military objective. But these are examples where you could potentially have a part of the natural environment that could become a military objective.
Thank you very much. I have a very specific question. So maybe it's been discussed when you all elaborated the guidelines. So someone is asking, is the increased energy cost and so carbon cost of digital infrastructure under the use of cyber warfare tactics considered an effect on the natural environment of armed conflict?
Sorry, could you repeat that? I don't see it on the Q&A.
Is the increase, it's a bit more at the bottom, is the increased energy cost and so carbon cost of digital infrastructure under the use of cyber warfare tactics considered an effect on the environment of an armed conflict?
I mean, I guess that's more a question even for Doug or Carl in terms of what the effects we see on the environment are more than on the law and how HL addresses that. So maybe we can come back to that. I mean, I don't see in general terms, I think it probably could be an effect of armed conflict on the environment. Whether it's then addressed by IHL and how is a different question. Yeah.
Great. Yeah, we'll leave that into the air. Maybe a last, maybe more IHL related question. So someone mentions the oil that was put in the video that was showed oil put in drinking water. So that person asks if that's considered an attack on civilian, targeting the civilians.
Sorry, I'm muted. Again, it really depends on the circumstances. I think there's different ways of seeing it. You know, and it very much depends on whether it is something that's happening in the conduct of hostilities or whether it's something that's happening under the control of one of the parties. So in the territory of a party that is not, you know, in the middle of hostilities. So it really depends on that, how IHL would look at it. There can be relevant rules of IHL, for instance, the prohibition of attacking objects indispensable to the survival of the civilian population, which, as I mentioned, could include drinking water. You know, it really depends on the specific circumstances and what was happening at the time. And I won't get into details on the specific context. Just, you know, in general, it really depends on what's happening on the ground and how we assess that.
Thank you very much. So it's now time for a short break. Thank you so much again, Helen, for your great remarks that covered a lot in little time. That's always hard to do. My colleague Karen is sharing in the chat function with you all the link to the ICRC report that Helen mentioned, When Rain Turns to Dust, that talks a bit more about the climate change aspect of it all. So you're encouraged, of course, to download it, check it out during the break or whenever. So yeah, we'll be back in about 15 minutes for our panel. So time to, we'll grab a drink or a little snack, and we'll be right back.
Thank you very much.
So I'd just like to let everyone know that we'll start in about 5 minutes. So we'll be starting in about 2 minutes. So yeah, last 2 minutes to go grab a snack, drink a water, maybe a coffee. We'll be starting in about 1 minute. Great. So welcome back, everyone. I hope you enjoyed the first part of our presentation this morning. So we'll be, there's still lots to say about the environment and armed conflict from an Icho, purely Icho point of view, but also many other considerations and legal and non-legal. And we'll be continuing with Doug Ware, who is the policy director at the Conflict and Environment Observatory. So Doug has undertaken research and advocacy on the environmental dimensions of armed conflicts since 2005, with a particular focus on conflict pollution and the toxic remnants of war, and the role of civil society in supporting policies that enhance the protection of the environment in relation to armed conflicts. He is a visiting research fellow at King's College London's Department of War Studies March Center, and has written widely on conflict and the environment. He is the co-founder of the Conflict and Environment Observatory, a UK charity that monitors environmental incidents and trends in conflicts and studies new approaches to data collection. It also monitors developments in law and policy intended to reduce harm and engages with relevant processes. The observatory also works with partners to mainstream the environment in humanitarian disarmament field operations. Doug, thank you so much for being here, and the floor is yours.
Excellent. Thanks, Mary-Laure. And yeah, thank you very much to the Canadian Red Cross and to Dalhousie University. I shall just share my screen. Excellent. And yeah, greetings from the other Halifax in West Yorkshire in the UK. Very nice to be connecting with you across the Atlantic. Yeah, so I'm just going to talk a little bit about some of the processes and drivers that have been behind kind of the last sort of 10, 15 years, where we've seen this real sort of renewal of interest and attention in the environmental dimensions of conflicts, and that's clearly flown through into developments in the legal sphere as well. You've done the introduction, so I don't need that slide. Thank you very much. So yeah, so this emerging PERAC framework. So PERAC is this protection of the environment in relation to armed conflicts, and there are kind of four legal components we can think of. One of them is the International Law Commission's draft principles on PERAC, which is in the progress of being finalised. As Helen's discussed, there are new guidelines on the protection of the environment in armed conflict. In addition, there have kind of been civil society NGO sponsored events as well and processes. So there's a group in Switzerland who developed the Geneva list of principles on the protection of water infrastructure. And that's obviously has not only civilian protection elements, but also elements of protecting the environment. And next week, we'll see the launch of a set of principles for assisting the victims of toxic remnants of war. And that's something we've been working on for a while with Harvard University. 30th of September, if you'd like to tune into that webinar as well. So yeah, so I just want to maybe just put an idea out there, which is kind of from the environmental movement, and it's this theory of shifting baselines. So with each new generation that comes along, we kind of see the environment and the state of the environment as the normal. Maybe a good analogy is maybe fishing grounds off the Grand Banks, it's in your part of the world, where for each generation of fishermen who come along, they catch a certain number of fish, and to them that's normal, but they don't know how many fish their parents or their grandparents caught. So with each new generation, we don't really notice the environmental degradation and it being damaged. And instead, it's kind of your new normal, which you're grown up with. So we have this, we find it quite difficult to sort of conceptualize and realize the extent to which the environment's being damaged by our action. And this is kind of the theory of shifting baselines. But if we kind of tip that on its head in terms of the sort of legal process around conflict in the environment, what we've instead seen is this shifting normative baseline that's reacted, it's been in reaction to how people have value systems around the environment have changed as we've understood more about it and more of how we depend on it and its importance and the extent of damage that we're doing to it. So just as an example, after the conflict in Kosovo, NATO had a very extensive bombing campaign which involved bombing industrial sites, famously the Pančevo petrochemical works, which led to quite a significant pollution incident. And it was one of the issues which the committee established to see whether NATO had committed war crimes and others had committed war crimes. One of the issues they looked at, and they looked at IHL and the thresholds of damage that's damaged us with widespread, long-term and severe. And they couldn't quite pin it down. There wasn't really enough data for them to work out whether the damage had been widespread, long-term and severe. But they did say, well, you know, it's probably fair enough, because what we would have seen is, you know, stuff like ordinary battlefield damage like we saw in World War I. Almost like this was kind of an acceptable level of damage. So I guess in World War I, on battlefields in France and Belgian border, actually we saw a very large area very severely damaged by this massive industrial use of artillery, in particular, trench warfare, which dragged on for years. We had scenes like this where you had sort of utter devastation of the environment. Similarly, and the impacts, environmental impacts of World War I are still very readily detectable 100 years later. You know, there's still extremely high levels of heavy metal contamination in some areas from all the metal casings of the weapons that were used. There's still explosive remnants of war there. And it's this question of, well, is this just acceptable battlefield damage, or to us now, does this actually seem entirely unacceptable? And it's almost this shifting normative baseline of what we think is fine, is okay in conflict. And one of the reasons we've kind of seen this is this sort of growing acceptance. The more we understand about the environment, the more we realize how complex it is, how fragile it is, and how reliant on it we are. And, you know, we see these sort of multiple crises at the moment around the climate crisis, biodiversity crisis, pollution. And when we look at what the environment does for us, you know, it's pretty significant. There are all these different roles it has. So cultural, aesthetic values, provisioning values, it's food, it's raw materials, regulates the environment, regulates water, regulates the climate, and it supports us through soils, plant life. And the current pandemic is a good example of this, you know, where it comes from a zoonotic disease due to human encroachment on rainforest, bringing us more into contact with viruses that are circulating in the environment. And from a conflict perspective, you know, with a lot of post-conflict countries where they have rainforests, we see massive spikes in deforestation after the conflict due to a lack of governance. So there's this direct sort of link in places like DRC and others where the conflict and insecurity and instability actually creates kind of a breeding ground for zoonotic diseases and increases the likelihood of our exposure and pandemics as we see today. So we're very acutely aware at the moment of these sort of profound connections between humanity and the environment, and that underpins this sort of change in value systems. But one of the things we've also sort of seen is this increasing understanding of environmental dimensions of conflicts. We know a lot more than we used to.
Doug, you have about 2-3 minutes.
2-3 minutes, right, I'll go quickly. So we saw some early conflict assessments back in the Vietnam War. We had research into the use of Agent Orange herbicides, chemical defoliants, tended to be done by academics and NGOs. After the 91 Gulf War, Greenpeace had quite a significant report on impact, which looks at these oil fires and oil spills. Since then, since 1999, UN Environment Programme, they've been doing these post-conflict environmental assessments, and this has really expanded our understanding of the environmental dimensions of conflicts. They're not perfect. They might be temporally limited. They might be spatially limited. They're post-conflict assessments a lot of the time, so they don't really notice what's happening during the conflict. But we know far more than we used to. And then from the sort of 2000s onwards, for us as NGOs and civil society, we've had far greater access to Earth observation, remote sensing data, open source intelligence through Twitter, social media. So it's made it a lot easier to monitor what happens during conflicts. And this here is us monitoring emissions from a burning sulfur factory in Iraq, and to be able to do it in almost real time using satellite information. And the implications of that is that it kind of drives policy and legal change. And this is a trend which is just going to increase as time goes by, with the use of artificial intelligence to automatically identify harm, big data, citizen science. We can use all these tools to start gathering more data on harm. And this is some of our work on Yemen, where we've got to look at all these different sources of big data to try and identify changes in groundwater and the drives of that. And this is just one small area of Yemen. And the implications of that for the legal framework is that also needs to develop alongside our understanding. And we already see some tensions around the use of the term natural environment. Should that just be environment, when we understand this sort of innate relationship between ourselves and the environment? But it's not just a question of how we implement and comply with the law. We're also going to need this ongoing progressive development to reflect our ongoing progressive understanding. And then there's always going to be limits to the law, to IHL, to what we can do. There's always going to be complex situations and conflicts. The situation currently off Yemen, where you have this aging tanker, which is threatening a huge oil spill, is a good example of this is going to be a diplomatic and a technical solution, not necessarily a legal solution. But then even with the legal framework developing as it has, we still have these real issues around preventing unacceptable harm, about how we provide environmental assistance, which is done on a very ad hoc basis at the moment, how we moderate the behaviour of non-state armed groups, and how we try and get accountability for harm as a way of then preventing further harm. But then it's kind of this crucial issue that even if we go in and remediate environments or restore areas, the environment's always going to be changed. It's always being disrupted. Its baseline is going to be shifted in the way that we saw at the start of the slide. So it's not a panacea where we can go in and suddenly solve these problems. We're always going to have this permanent scar on the environment, permanent change due to conflict. And that's about me. Thank you.
Thank you very much, Doug, and hopefully we'll be able to go back to some of the elements you just mentioned at the end during the Q&A. So I'll just move now to our next panelist, Commander Karen Zuetsko, who is with us in Halifax, not in the middle of a tropical storm, so that's great. That was a few days ago. The worst is behind us. Commander Zuetsko attended St. Francis Xavier University in Antigonish, Nova Scotia, where she earned her Bachelor of Science with an advanced major in psychology. On a whim, she decided to apply to law at the University of New Brunswick, and she was accepted and graduated with her LLB in 1999. And then she moved to St. John's, Newfoundland to complete her articles, and she was called to the Bar of Newfoundland, Canada in June 2000. In September of that year, she joined the Canadian Forces as a direct entry officer in the Office of the Judge Advocate General. She was posted to a CFB Gagetown in New Brunswick in August 2001 and spent 3 years then giving legal advice to the Army units there. And then in 2004, her component transferred to the Reserve Force, remaining with the JAG branch, Judge Advocate General, and she was promoted to her current rank and position in November 2017. She oversees the provision of legal advice to reserve units for the Atlantic region of Canada. She has also assisted the Assistant Judge Advocate General Atlantic Office with multiple legal issues, instructed countless courses for the JAG branch, and has advised many units on various legal matters. She has also acted as a legal advisor to a board of inquiry, worked on the intermediary law of armed conflict and military justice at the summary trial level reviews for the Canadian Forces Military Law Center, and provided legal opinions to the administrative law branch as well. And she is also an IHL instructor at the Schulich School of Law at Dalhousie University, and is also a part-time instructor at Mount St. Vincent and St. Mary's Universities here in Nova Scotia. Welcome, Commander Zuetsko. I will now share your PowerPoint presentation. If I can just,
Thank you very much for that introduction. Very happy to be here again at the IHL conference.
It seems that we're having a little bit of trouble hearing you well.
Okay, is that any better?
Oh, that's better, yeah.
Sometimes my microphone shifts on me.
Oh, okay. That could explain it. I'm just gonna.
So while that presentation is coming up, you'll see that this is going to be kind of a shift from what we've been talking about. So less of the general ideas about the environment and the protection of the environment within IHL, and more about what the CAF does on the ground when we're trying to meet our international obligations under the various legal frameworks during deployments, which of course there's CAF members across the world at most times during any given year. And so there's always obligations on us to make sure that we are following the rules under IHL, and that with respect to the environment is no different.
Sorry about that. Here we go. For some reason, at some point, it had left my screen. There we go.
All right. Okay. So next slide, please. This presentation is going to try to talk about 3 or 4 different things in the 10 minutes. A general overview of the legal framework when we have Canadian Forces operations. And I'm going to go through that fairly quickly because a lot of it has already been covered in the other presentations. And then I'm going to talk about kind of 3 different things: planning, execution, and closure of operations. So what do we do before we go and deploy somewhere internationally? What do we do when we're on the ground there? And then what happens after the conflict? Okay, next slide. So as you've already heard, there is a legal framework with respect to the environment, okay? And there are both specific rules and rules that provide protection in sort of a incidental manner. When you're talking about an international armed conflict, which is the type we don't tend to see very much these days, but the state-on-state kind of conflict, we have all kinds of set rules in our additional protocol 1 about protection of the environment. And this was already mentioned, you know, widespread, long-term, and severe damage. We should not be doing that. We also cannot attack anything that will harm the natural environment, prejudices the health or survival of the population. So there's a prohibition right away on anything that we can do that might harm a population or cause long-term damage to the environment. Next slide. We also have no reprisals with respect to the national environment, so we're not going to go and harm the environment of a population because of something that was done to us in the conflict. And then there's also the NMOD Convention, Environmental Modification, which talks about, again, any sort of weaponry or technique that would deliberately change the environment is going to be prohibited. And the Canadian Armed Forces in Canada is a signatory to that convention. If we get into the non-international armed conflicts, which are the majority of conflicts that we see in the world today, we have less direct protections, but additional protocol 1 does also provide indirect protections. So in the next slide, it talks about various things with protections such as if there's civilians in the area, the environment is part of the area that we don't protect or don't attack, and that was already referenced. We don't want to have any attacks on the environment that would cause a civilian to flee their home, or anything that might harm livestock, crops, any sort of starvation of the civilian environment or population would be prohibited as well. Next slide. And also any sort of man-made objects that, if attacked, would cause some sort of environmental impact is going to be prohibited. And there's also prohibitions on things like pillaging, which could have an impact on the environment. So we're going to say you're not allowed to go in and take certain sort of species, plants, animal souvenirs that could have an impact on the environment. And depending on the nature of the deployment, so there's different times when the Canadian Armed Forces might deploy in an international operation. So one example would be merely, and not merely, but if there has been some sort of environmental catastrophe somewhere in the world. So we might deploy Canadian Armed Forces members to help after an earthquake, for example, to help with the water supply or to rebuild infrastructure. Okay, so that's one reason why we might be overseas. Another is that we are there post-conflict, again, to help with demining a minefield, for example, okay, some sort of environmental cleanup. And then we have the situations where we are there during the conflict as well, right? So on the ground in the bombing campaign against ISIS, you know, we're on the ground during the conflict. So those are kind of different situations of when we would be there. And depending on the nature of the operation, there might be a NATO operational rule that has to be followed with respect to the environment, or something that's in the UN resolution that has allowed that operation to go forward that would also have to be followed. So there's a lot of different legal framework that we'd be looking at when we're determining what we should be doing, okay, when we are deployed overseas. So next slide. So with respect to the planning phase, it's very important to ensure that the environment is taken into consideration when operations are being planned. And depending on the nature of the operation, again, if it's a catastrophe and we're quickly going over with the DART team to provide water, there's going to be less ability to plan than if it's a more longer term operation. But we always want to make sure that as a start, we look at the host country's environmental laws. Okay, so that is, we would have an agreement which we call a status of forces agreement with the host country. It deals with many different facets of an operation, but one is the environmental facet. Okay, and so we would sign that agreement saying, okay, we're responsible for this part of these criteria, you guys are responsible for that part, the host nation, and we would want to make sure that that is signed before we deploy. So we're always going to have a status of forces agreement, and it mentions here the NATO legal desk book, okay, as one of those sources. Next slide.
And just to quickly, sorry, 5 minutes left.
Oh, okay, perfect. I think I'm halfway through. Now, the fact that we have a status of forces agreement and are aware of the host nation environmental laws doesn't change the fact that we also have to comply with our Canadian environmental laws as well. So one of the things that we talk about in the Impact Assessment Act is an environmental effects determination. And this says the federal authority may not carry projects outside of Canada or provide assistance outside of Canada unless there is this environmental assessment. Now the next slide will tell you sometimes we don't have time to go through the environmental assessment. So again, depending on the nature of the conflict, if there is some sort of emergency and the project has to be carried out without delay to best help the environment or the public or safety, then we would go without that sort of assessment. But in any sort of conflict situation or post-conflict situation, we'd be doing those sorts of assessments before we deploy. Next slide. It's also important in the planning phase to think about what sort of documentation that we're going to keep, because anything that happens while we're overseas is something that could come back many years down the road, right? So if there is some sort of environmental impact, we want to be able to make sure that we can assess and deal with that after the fact. So any sort of actions that are taken while on the ground are going to be well documented and kept forever, it says here, right? So we'll make sure that we keep that documentation in the event that the host country or individuals within the host country have some sort of claim later on. Okay. Any sort of time, you know, often when we're deployed, we're going to be having agreements with contractors in those other countries, or we're going to be using bases or infrastructure in the other countries. So we will have agreements in place that talk about who is liable for what, and we want to make sure that we cover whatever liability we can through those agreements so that there's no sort of issues left on the ground after we leave. Okay, next slide. There's also environmental baseline studies and closeout studies. So the environmental baseline study, what you would do when you initially arrive in the host nation to make sure that you know what the baseline is at the time, and then another closeout study when you're leaving to make sure we know, okay, what happened while we were here, while we were using this base in, you know, Kandahar, what sort of damage occurred because of our use of vehicles, our oil that was there, any other sort of things that we might have left on the ground. So it talks here about site plans and pictures and soil samples, making sure that we compare how the earth was when we got there to how it is when we're leaving, so we can remediate any of that sort of issues. And then we also want to make sure we keep all of our hazmat inventories in check so that we know here's everything we have that could be dangerous, here's how we're keeping it safe so that there isn't an issue when we're on the ground. Okay, so that's kind of all the things that we consider before we deploy. Next slide. So during the execution phase, as already mentioned, if we comply with Canadian law, then we're probably going to be fairly safe. A lot of the places where we operate, the host country law would actually be less restrictive than Canadian law. So the default would be apply the Canadian law, and then we won't, you know, we should be okay. So you're not going to be pumping fuel from trucks or sewage from the camps into any sort of water source, for example. And we're also going to keep a close eye on any sort of substances that we may have. So even if it's not currently regulated by that host country, we would still want to make sure that we're not releasing any sort of substances in the setup of the camp, okay, and the maintenance of the camp.
So we're at 1 minute left.
Oh no, okay, next slide. Okay. And as much as possible, as I've already said, we're going to prevent our damages. So when we're leaving the site, we're going to do that environmental closeout study. So we'll know what the site looks like when we're leaving. Next slide. And we're going to have various documents that we're going to sign to make sure that any sort of liability is closed off. We're also going to take all measures we can to make sure we don't bring anything back to Canada. So not just protecting the environment there, but making sure we don't bring seeds, soil, anything that could harm our Canadian environment back with us when we bring our vehicles and back to Canada. And also make sure that we haven't harmed any wildlife while we're deployed. Next slide, very quickly. In the closure phase, you know, cleanup can take a very long time. This is why it's so important to keep all of the paperwork that we've already talked about in the planning phase. And then the next slide just talks about the fact that we do have the ability to pay out, oh, sorry, so I'm one ahead. So as I've already mentioned, those NATO SOFA agreements, to make sure that we know this is what we're responsible for, this is what you're responsible for, so we can ensure that any contamination is cleaned up after the operation. And then the last slide references the fact that we have the ability to pay claims in the event of any damage that cannot be remediated. We have the ability to pay claims to individuals or organizations up to $10,000 if it's on the ground, and then larger issues would come back to Canada and be solved from here. So every deployment has a legal officer on it who kind of goes around and makes sure that all the rules are being followed and any claims are actioned. So that's what I have. Thank you very much.
Thank you very much, Commander Zuetsko, for your very instructive presentation. Again, a lot, unfortunately, to cover in so little time, but hopefully we'll be able to address some of that during the Q&A. We'll have quite a bit of time. So I will now move to our last panelist today, while I pull up his bio that, again, like many others, had disappeared from my screen. So Carl Bruch is a director of international programs at the Environmental Law Institute and the founding president of the Environmental Peacebuilding Association. He's an authority on environmental governance and has helped dozens of countries throughout Africa, the Americas, Asia, and Europe strengthen their environmental laws, institutions, and practices. And he has also provided technical and legal assistance, built capacity, and conducted research across the world, including in many conflict-affected countries. He has edited more than 10 books and authored more than 80 journal articles, book chapters, reports. And in addition to the Environmental Law Institute, he has worked for the UN Environment Program and the Environmental Law Alliance Worldwide, and is a lecturer at American University's School of International Service. So welcome, Carl. Thank you very much for joining us. And now I will share your PowerPoint presentation.
It's an honor to be here, and very great pleasure to be on this distinguished panel. I'm going to continue a few threads that have been mentioned in the earlier presentations and expand them. I'm going to be looking broadly at environmental peacebuilding, and then the law that kind of applies more broadly in that context, focusing particularly on the draft principles of the International Law Commission. Next slide, please. So environmental peacebuilding can be defined as the process of governing and managing natural resources and the environment to support a durable peace. This is a broad umbrella that includes efforts to prevent conflict, mitigate, resolve, and recover from violent conflict. It's really focusing on the environmental dimensions of those different processes. It involves everything from renewable resources such as land and fisheries to non-renewable resources such as oil, gas, and minerals, and includes ecosystems and their services, including considerations of climate change. It operates across multiple levels, and it's, I think, important to think of this as involving both the addressing the risks posed by environment to peace and by peace to the environment, as well as the opportunities. And so look at negative peace and positive peace. Next, please. So this is an arc that seeks to show more graphically how everything fits together. And you can see here across the conflict life cycle from before conflict, as there are disputes, it escalates. So you have unstable peace, crisis, armed conflict, resolution of the armed conflict to an unstable peace, to a stable peace, to a durable peace. So that's the timeline. And you see within the colors the different interventions that, whether it's the UN or bilaterals or regional bodies may take. And above, you'll see the risks, and everything from how grievances over inequitable land distribution could cause conflict, to conflict resources, to providing incentives for peace spoiling. These risks are often termed environmental security. The more opportunistic interventions, that opportunities for building peace, are in the bottom in the black. And so I won't go through this in light of time, but I'm happy to share the graphic and the presentation, and this is written up elsewhere. Next slide, please. Historically, international law has focused on targeting of the environment during conflict. And if you remember in that arc, at the top there was environment as a weapon of war and targeting. We see this with scorched earth tactics in World War II and in a number of other conflicts. Widespread defoliation, such as we saw in Vietnam. The release of dangerous forces, such as dams or nuclear power plants. Environmental modification. For those who are not familiar with this term, this came about because the US was seeding clouds in Southeast Asia, trying to bog down the Viet Cong. And there was a lot of concern about playing with the forces of nature at such a scale. So that's historically where international humanitarian law has focused on environmental considerations. However, over the last several decades, we've seen a change in the nature of its conflict and in the effects that conflict has on the environment. There's a rapid growth of non-international armed conflicts, hybridized armed conflicts, prolonged conflicts, terrorism. This is not the more traditional international armed conflict that is much better addressed by international humanitarian law. We also see the rise of conflict resources to finance armed conflict, and a resurgence in the targeting of civilian infrastructure, particularly water infrastructure. There are also changes in international interventions. There's a lot more work now on early warning, diplomacy, and conflict prevention, trying to catch disputes before they escalate to armed conflict. We see natural resources often being used as an incentive to end armed conflict. This is often referred to as environmental peacemaking. There are growth of chain of custody systems and due diligence to try to address conflict resources. And since the end of the Cold War, there has been a rapid growth in post-conflict peace building and natural resource dimensions there too. All of this has motivated efforts to revisit international law. Next, please. I should also indicate that this, as Helen mentioned, the draft principles that the International Law Commission has developed they complement the work of the ICRC guidelines, and both are very important documents in articulating where international law currently stands. but they are complementary. And I think that that might be something that's worth discussing further in the discussion. The International Law Commission, for those who don't know it, was created in 1947 to initiate studies and make recommendations to encourage the progressive development of international law. And starting in 2013, continuing now, they have taken up the issue of protection of the environment in relation to armed conflict, producing a series of 5 reports and 28 draft principles. These principles were provisionally adopted in 2019, and right now they're going through consultation with member states and others. And I want to acknowledge the leadership of Ambassador Marie Jacobson from Sweden and Ambassador Mario Leto from Finland, who have been the special rapporteurs and have been instrumental in the development of these principles. Next, please. The principles are important for 3 basic reasons. Their scope, the scope of the substance, the scope of the sources, and then the consideration of non-international armed conflicts. It should be noted that the principles both codify existing international law and they make some progressive development. Next, please. In terms of the scope, it was when the ILC first took it up, there's a question about what should they focus on? Is it only what's happening during armed conflict? And the Ambassador Jacobson, the special rapporteur, decided in consultation with the ILC that no, the term that was that they talked about there was protection of the environment in relation to armed conflict, and this means across the conflict life cycle, and this is an important expansion in consideration beyond the traditional focus on what happens during armed conflict. It also focuses on some of the more traditional elements of pollution and environmental destruction, but then it, in a more contemporary manner, it also looks at the illegal exploitation of natural resources. It retains a primary emphasis on states, but it also recognizes that other international organizations, non-state actors, and the private sector are also relevant here. Next, please. In terms of the sources, the approach that the ILC took here builds on 2 previous analyses. One is the work of analyzing the effects of armed conflict on treaties, and the other is on fragmentation of international law. And between those, the ILC said, recognize that there are lots of bodies of law that speak to the environment in relation to prevention of conflict, during conflict, and after conflict. This includes international humanitarian law and the law of occupation, international human rights law, and Marie-Laura did a nice job of highlighting some of these: international environmental law, international criminal law, the UN Charter, international trade law. And so for the first time, the UN has really focused on the different bodies of law that all apply and how they can be seen in a more coherent manner to protect the environment in relation to armed conflict. Next, please. The final area in which the principles are significant is that they apply to non-international armed conflicts. Most international humanitarian law has one set of provisions on international armed conflict and another set of provisions on non-international armed conflict. And generally, states have been more willing to impose restrictions on international armed conflict. By resorting to human rights law and international criminal law, they've been able to, and the other bodies of law, they've been able to provide stronger protections for non-international armed conflicts. So the principles as they're drafted generally apply in relation to armed conflicts, and they don't specify international armed conflict or non-international armed conflict. And I'd like to close by inviting people who are interested in these topics, next slide please, to investigate the Environmental Peacebuilding Association. It's a multidisciplinary forum that addresses environment, conflict, and peace. There's a very active law interest group and a lot of activities going on. We have more than 350 members right now in 60 countries, and we'd be very happy to talk to you. That, I thank you for your attention.
Thank you very much. Yeah, there are other important elements mentioned in that presentation. Again, such a short amount of time, but we had quite a few very interesting questions coming in through the Q&A. So we have, yeah, we have some time to answer them. There's one that might be maybe best directed, and we encourage people to keep asking questions in the Q&A. And if you want to direct your question specifically at one of the panelists, please indicate so when you write your question. So there's one here that maybe Doug Ware could answer. So someone asked, remote sensing has allowed us to track pollution caused by conflict in better in real time, but do you think a lot of this monitoring is done post-conflict just because it's so difficult to ensure safety of monitoring teams in active war zones?
Yes, yeah, I think this remains a key issue, and I think it's, there's a lot we can tell from the air using remote sensing, but it's very difficult to verify things on the ground, and at some point, that can be very problematic. So in northern Iraq, when the oil fields were burning, there were IDPs who were shifted to camps just near the oil fields near Kiara, and they were living under a black sky for months on end, but there was no environmental air quality monitoring being undertaken. So it was a direct public health issue for them. And that was one of the contexts where low-cost monitoring for using some of the citizen science approaches, which we see in peacetime quite regularly, looking at, for example, traffic emissions around schools in cities, could be deployed in a conflict setting by humanitarian organizations and others. So there's a lot of potential for creative ways to start gathering more data than we do at the moment.
Thank you. Then another question came in, maybe more for Commander Zuetsko, or Helen as well, or whoever would like to take this one up. Is ammunition with depleted uranium tips forbidden to use under current regulations and laws applicable to the Canadian Armed Forces?
So yeah, so the Canadian Armed Forces is very proactive in the regulations that we follow. So we would not be using that type of ammunition in our operations. We would still work with some countries that potentially do, but we would not be using that particular type of ammunition.
Thank you. A question came in that maybe Helen might answer. Someone wanted to know to what extent states had been involved in the development of the new guidelines, the new ICRC guidelines.
All right, and I'm just trying to open up my window. Here it is. Yes, thank you very much for that question. I had seen it in the chat, so thank you for bringing it up and giving me space to answer it now. So as a general, I guess, point before going to that, the guidelines are, as you know, and as I mentioned during the presentation, they were sent to a group of external peer reviewers who reviewed the guidelines in a personal capacity. So some of these peer reviewers obviously were, had state represented at certain states, although as I just said, the review was in a personal capacity, but states were represented, and one of the things that we really looked to do was to ensure diversity of these peer reviewers, not only in sort of subject matter, so IHL experts, environmental law experts, practitioners, people from the military, but also in terms of geographic diversity. So that's something we really tried to do. But as I mentioned, it really was a personal capacity peer review. And in the end, the guidelines are published under the sole authority of the ICRC and represent ICRC's legal interpretation of existing IHL rules. So as the approach we have taken, for instance, in the project to update the commentaries to the Geneva Conventions, state consultations did not take place in the guidelines. This is because a select state consultation could be viewed as preferential treatment for some states, while a consultation of all states was simply unfeasible for the ICRC. So like the approach of the commentaries, we did not do a state consultation, but as I just said, to ensure that we reflected diverging positions and cross-regional views, we did consult a diverse group of academics and practitioners and really aim to include in the guidelines diverging views where these exist, or where we were aware of these.
Thank you, Helen, for that's the process is always very important as well. We have a next question that Carl offered to answer. So one question that was asked is, are the consequences to infractions to the law prosecuted through the international court or international courts only? How many successful prosecutions have occurred?
And I think this is an important question because some other people have alluded to, okay, you've got the rules, so what? Do they, and you know, there are some member states like Canada who are very proactive, who try to incorporate, they train, they do this, but what happens when there are violations? And we have seen a small but growing number of cases in a variety of forums. So it's much more than the International Court of Justice. There is one decision between DRC and Uganda dealing with pillage of natural resources that the ICJ decided. We've seen a growing number of member states prosecute cases, and this is generally where prosecutions should happen in the first place. And it should be, you know, it's more for the international tribunals when states don't prosecute. We've seen the Netherlands, Spain, France, Switzerland, others prosecute cases, some successfully, some did not stick. And we see a lot of ad hoc tribunals, some dealing with scorched earth tactics, some dealing with pillage, the Nuremberg and Yugoslavia tribunals, and the UN Compensation Commission, the Ethiopia-Eritrea Claims Tribunal also dealt with violations of international law as it related to natural resources and the environment. So it's still a relatively small number of cases for the number of violations, but it is exciting to see the number of different forms in which this is happening, and it's becoming more regularized that one can and should prosecute the cases and the violations.
Thank you very much. It is, yeah, a question that I think many practitioners and researchers in international are getting asked about compliance and prosecutions. There's another question that I think a few of you might want to provide some answers to, some answer elements at least. Someone asked a bit earlier, to what extent do you see the precautionary principles? There's always these words as a French speaker that are hard. Precautionary principles of environmental law coming into play when making the proportionality assessment of potential environmental damage during the planning and execution of an attack? And also, do you see a difference in the ability of some of non-state armed actors versus military state forces in making such environmental assessments? I don't know if anybody wants to jump in or on the precautionary principle.
I can take part of that question unless another of the panelists that hasn't spoken yet would like to. I guess I can start, and maybe others can complement me. As I think Marie-Laure in your presentation, and I also mentioned in mine, under IHL, you have the principle of precaution, which essentially, and this is something that we cover in Rule 8 of the guidelines, whereby in the conduct of military operations, constant care must be taken to spare the civilian population, civilians and civilian objects, including the natural environment. And all feasible precautions must be taken to avoid and in any event to minimize incidental loss of civilian injury, damage to civilian objects, including the natural environment. So here, I mean, this is very clearly the principle of precautions under IHL, which, as I discussed in my remarks earlier, is applicable to the natural environment as, by virtue of its civilian character. And here, the precautionary principle in international environmental law is of particular relevance, for instance, because the potential effect on the environment has to be assessed in the planning of an attack. And as part of this precautionary principle, which has been gaining increasing recognition, there is practice to the effect that that the environmental law principle applies in armed conflict, and that the lack of scientific certainty as to the effects on the natural environment of certain military operations will not be sufficient to absolve a party to conflict. So essentially, just to say that under IHL, we have the principle of precaution, which applies to the natural environment, but that as part of that and taken sufficient precautions, the precautionary principle for international law can be of relevance to the planning of an attack.
Thank you very much, Helen. And I don't know if any one of our other panelists might also just expand really quickly for those who are not familiar with the precautionary principle, quickly explain what it entails, and of course add more on this specific question as well.
I'm happy to kind of do that and take a shot at the second part. The precautionary, the two precautionary principles are a great topic if you're looking for a paper. They're both trying to err on the side of caution, but they frame it differently. And in international environmental law, the precautionary principle, or the principle of precaution, basically says that the lack of complete knowledge about what is happening should not prevent you from taking action. So if you don't know precisely how much the climate is going to warm, that should not preclude you from trying to fight climate change. If you don't know, if you have indications that chemicals might harm public health, but you don't know exactly in what ways, that should not prevent you from starting to regulate them or taking action. So it's a little different in the framing, and I think that's an important question to look at. With regards to the second part, difference in the ability of some non-state armed actors versus militaries making such environmental assessments. I think that, for certain environmental assessments, that's probably true. I think, we're dealing with a target-rich environment here. There are so many violations that a lot of these, it does not take a lot of sophistication to do the analysis. And if you're talking about poisoning wells or pillage, there are a lot of things that are being done that really should not be done. It's clearly prohibited. And some of these line drawing questions are not as, they're not dealing with weapons that are as sophisticated or expensive, or that yield such widespread impacts that doing that sort of analysis is necessary for non-state armed groups. So I think that in principle, yes, there are differences. In practicality, most of what we're seeing and trying to address, we don't need to, there's no defense of lack of ability or lack of capacity.
Thank you very much. I don't know if Doug, you wanted to add something. Otherwise, there's another question that came in that you might want to address as well.
I'd just say very briefly about the precautions in attack, maybe just about some of the complexity involved in trying to predict the effects of, say, an attack on an oil facility or industrial site, and how much you need to know about the disposition of the site, as well as the process which is there and what's going to happen if you target it. And we saw in the early stages of the conflict in Syria, very widespread attacks on oil infrastructure, particularly with Russia, for example, who were causing quite devastating attacks on oil refineries and facilities. And because Islamic State had taken control of these, it was justified militarily as a legitimate target to try and reduce their funding and financing. But we actually saw quite significant environmental pollution events on the back of that. And yeah, some states are probably more open to this idea than others, I think, would be the experience.
Thank you. There might be one more question for you to keep on going, and then maybe one last question that we saw that Commander Zuetsko could address, and then that would be the end for us for today. So someone asked a rather, let's say, general question, but you might have some something to say about that. So someone asked, how much do these cleanup efforts actually restore the area to pre-warfare conditions? Can they do to an extent?
Very rarely. I think that's one of the sort of key issues we face, is that because there is no clear obligation on states to clean up after the damage they've caused, then actually a lot of the remediation work we see is pretty ad hoc. There'll be areas, but they, for example, in northern Iraq, UN Environment got some funding, some support from the international community to be able to do some oil cleanup after the mess that Islamic State caused. But in a lot of cases, states are often left to deal with contamination and pollution issues themselves and environmental degradation issues. There may be some support coming from the international community, but it's not done as standard, it's ad hoc. And a lot of the time, these projects may go on for years, so there's still environmental remediation work being done from the 1991 Gulf War in relation to the UN Compensation Commission, so some of the cleanup of the marine areas along Saudi Arabia and Kuwait. So these issues that we see are long-lasting, and at the moment, it's very hit and miss as to whether the places get cleaned up, and there's a big disparity between that and perhaps explosive remnants of war, where you have treaties in place and obligations on states to clear and try and remove landmines and explosive remnants of war. But for environmental remediation and cleanup, it's not something we see at the moment.
Thank you very much, Doug. Maybe a final question about the Canadian Armed Forces. So someone asked, does the Canadian Armed Forces seek to include environmental protection articles in all of its status of force agreements, noting that many states do not utilize such articles in their SOFAs? Do you see these as being important?
So certainly we try to incorporate those as much as we can, because they are very important. Okay, it's one of our obligations under international humanitarian law to worry about the environment. For those states where we cannot, those provisions are not included, or where perhaps their provisions would actually be fairly weak, then we just use the protocol of following Canadian law. So acting as we would if we were within Canada, and that kind of fills in any gaps that you might have in a SOFA. Yeah, and we do have the ability as well to remediate, outside of, again, the obligation that would be for that host nation, if we decide that it's something that we need to do.
Great, thank you very much. So we are right on time. That doesn't happen necessarily often. So I would like to, on my behalf, and of course on the Canadian Red Cross's behalf, thank our four great panelists today. That's of course, a very timely, important, crucial issue nowadays in times of armed conflict, and of course outside of armed conflicts as well. A great big thank you to the ICRC as well for their support for the organization of this conference, and of course to all the members of JERILS at the Schulich School of Law at Dalhousie University. It's always great to work with everyone. Some of you have worked with for the past 2 years, so it's always a pleasure, and hopefully we'll be able to organize this conference for many years to come. Without further ado, I'd like to yield the floor to Claire Langley, who's co-president of JERILS, for her final remarks.
Hi, everyone. Just on behalf of JERILS and Dalhousie, we want to say a heartfelt thank you to all of our panelists, Marie-Laure from the ICRC and everyone involved, and also to all of our attendees. It was so exciting and so cool to see such a diverse group of people represented, and we're very, very grateful that you all took the time to join in today and pose such thoughtful, thought-provoking questions. These conversations are so essential just for us to be having as law students and then to continue on throughout our lives. I think this topic is especially prevalent given everything going on in this world today. And despite everything that's happening with COVID and a lot of the isolating feelings that it can bring, I think conferences like this really bring together and unify us in a way that's really special and may not have been possible had it not been for such a virtual platform. So we're very, very grateful. I did just want to mention on behalf of everyone here at JERILS, we will be making a donation on behalf of each of our panelists to the organizations of your choice. So we will be reaching out and getting in touch with you to figure out which organization you would like that donation to be made. It's the least we can do as a thank you for taking the time to speak today and prepare such wonderful presentations. Again, thank you all to everyone. We really, truly appreciate it. And we couldn't have done it without your support. So thank you very much.
Thank you so much, Claire. I am sharing with everyone some quick instructions to fill out the evaluation for the conference. It literally takes a minute to a minute and a half, very, very short. We value your comments. We write long reports on our conferences, including these comments. So we invite you to go to Slido online and just type in the event code, DAL IHL, DAL-IHL, and just answer a few questions. So we'd like to thank everyone for attending. A big thank you again to all of our panelists. And yeah, just don't hesitate really to go and visit the websites of their respective organizations. There are plenty of amazing reports, documentation, blog posts on all these fascinating topics. So yeah, lots to be learned and discussed still. So wishing you a great weekend, everyone. Thank you.